What happens when your personal life becomes the reason you lose your job? Today, we're looking at a case that asks a surprising question. Can an employer fire you because of who you're married to? Most people assume marital status discrimination means you can't be treated differently just because you're married. But what about being married to a specific person? The answer isn't as simple as you might think, and the court's reasoning in this case just might surprise you. By the end of this video, you'll understand what marital status discrimination actually means under the law, the difference between something that feels unfair and something that is truly illegal, and how courts analyze these kinds of discrimination claims. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider, and on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. When most people hear the name associated with today's case, they think of television and celebrity headlines, but this story is not about tabloid drama. It's about employment law. It's about how one phrase in a statute can decide the fate of an entire lawsuit. And it's about a workplace question that most people have never even considered. Can your employer fire you because of who you're married to? Today we are talking about Kelvin Hunter v. Debmar-Mercury, a case that reveals a surprising gap in workplace protections under New York City law. Let's get into it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. Kelvin Hunter is best known as the former husband of Wendy Williams, the longtime host of The Wendy Williams Show, which aired from 2008 to 2022. But beyond that personal connection, Hunter also held a major professional role behind the scenes. He served as the show's executive producer from its very beginning until his termination in April 2019. According to his complaint, this wasn't a symbolic title. He was deeply involved in the show's day-to-day operations and overall success. His responsibilities included selecting and approving on-air guests, collaborating with company leadership on creative direction, managing production decisions, and overseeing the show's daily operations. The company behind the show, Debmar-Mercury, is a national television syndication company that finances, produces, and distributes television programming. Its co-presidents, Ira Bernstein and Mort Marcus, manage the company's daily operations, including staffing decisions for its productions, The Wendy Williams Show among them. So before the headlines, before the divorce, and long before the lawsuit, Kelvin Hunter had built a significant professional presence behind the scenes, contributing to a daytime show that dominated ratings for more than a decade. According to the complaint, everything changed in April 2019. On April 11th, Kelvin Hunter learned that his then wife, Wendy Williams, had filed for divorce. A week later, on April 18th, he received a termination notice from Debmar-Mercury. The letter came from co-president Ira Bernstein, and it read, in part, "Out of respect for our 10-year working relationship, we had hoped to meet with you in person and travel to New York to do so. But unfortunately, you canceled today's meeting, and we are left with no choice but to communicate to you in writing that effective immediately, your role as executive producer of The Wendy Williams Show is terminated, and your professional relationship with Debmar-Mercury is also concluded." The letter goes on to say you are no longer permitted on the premises. All communication regarding your transition, including the collection of your belongings, should be handled through your attorney, as you have indicated that you are represented by counsel. The letter ends with, "Thank you for all your contributions over the years, Kelvin. We wish you well." And that was it. No performance issues, no disciplinary history, no explanation tied to his work. Just an immediate termination following the divorce filing. Hunter argued that the timing and the complete lack of job-related reason shows that he was fired because of his marital relationship to the show's host, Wendy Williams. And in March 2022, Kelvin Hunter filed a lawsuit under the New York City human rights law. And if you live or work in New York, this is where understanding the New York State human rights law becomes important. I have a full harassment and anti-discrimination training that breaks this down in plain language. It covers both the New York State rights law and the New York City human rights law, including the broader protections that New York City provides. And if you're outside New York, the federal version can help you understand your rights too. So, under the New York State human rights law, Hunter he alleged one claim, unlawful termination based on marital status. Hunter argued that he was terminated because he was married to Wendy Williams. The company did not cite any job related reason and that their decision was triggered by the divorce filing, and firing someone for who they are married to is discrimination. And on the surface, many people might argue that this feels like discrimination. But in the legal world, the question is a lot narrower. It asks, does the law consider this marital discrimination? Debmar-Mercury responded quickly. They asked the court for permission to dismiss the lawsuit. They argued that even if everything Hunter said was true, it still wouldn't violate the law. Why? Because New York courts, both state and federal, they interpret marital status discrimination in a very specific way. According to those courts, the law protects against discrimination for being married, for being unmarried, for being divorced or separated. But it doesn't prevent discrimination based on being married to a specific person. So, under the existing legal definition, you can't be fired for being married in general, but you can be fired for being married to a particular individual. It's a narrow interpretation, but it's the only one courts consistently use. But the district court refused to dismiss the case. The judge said that even though the law prohibits discrimination based on marital status, there was at least a plausible argument that this termination happened because Kelvin was married to Wendy Williams. After the employer's motion to dismiss was denied in the district court, Debmar-Mercury appealed. And in April 2025, the Court of Appeals agreed with Debmar-Mercury and dismissed the case, not because Kelvin's recollection of the events were inaccurate, and not because the firing was justified, not because the employer acted ethically. The case was dismissed because even if the employer fired him because of the divorce, it's not considered marital status discrimination. Under New York City law, this case was dismissed on a legal technicality. The statute simply does not cover this kind of situation. And that distinction between what feels unfair and what is legally actionable is where many employees get blindsided. If something in this case felt familiar, don't ignore that feeling. You deserve clarity, respect at work. You deserve support. If you need a little guidance, I've created a workbook that can help you understand the distinction between something that is legally protected and something that's just unfair. It's there for you if you choose to use it. I'll include a description below. This case is an important reminder of a few things. First, not every termination is illegal. Employment laws protect very specific categories, not everything that feels wrong or personal. The harassment training videos on my channel, they break down those protections that employees have. Second is that understanding the exact legal definitions, that matters. Marital status discrimination, it doesn't mean what a lot of people assume it means. And this case makes that clear. Third, documentation, it's important. When an employer gives no performance reason at all, it raises questions, even if the situation doesn't fall under a legally protected category. HR leaders and business owners need to take the time to document performance issues as they happen. And finally, always check the laws in your own state or city. Protections vary widely, and what's covered in one place may not be covered in another. And it's important to remember that personal matters, personal issues, they have to be separate from employment decisions. Because even if a choice is technically legal, it can still create ethical concerns within an organization and internal discord. It can place the reputation of that employer at risk. And in employment law, how a statute is interpreted can determine whether a decision holds up under scrutiny. Kelvin Hunter v. Debmar-Mercury shows us that protections at work are only as strong as the language used to define them. Sometimes a firing can feel retaliatory, personal, or very unfair, but that still doesn't fall within the boundaries of what the law prohibits. And that's why understanding your rights, the limits of those rights, and how courts interpret the law is so critical. Thanks for watching the HR Insider. Real legal cases, real workplace rights. This is Harlow, and I'll see you in the next video.